Welcome to the False Claims Act Insider, presented by Price Benowitz. With more than 15 years of experience as an attorney focusing on qui tam law, Tony Munter explores the risks and heroism involved in being a whistleblower alongside distinguished attorneys.
Hey, Rebekah, how are you?
Tony, good. How are you doing?
I'm all right. It's a pleasure to have you. Thank you for agreeing to do this.
No problem. That is a very professional background you have
I
there.
like that. Yeah, I have a green screen and it actually works. It's pretty cool. Normally you'd see my my little cubby,
Yeah.
but for this we're trying to look the part anyway.
Yeah, it's an improvement. This is my guest bedroom in my house.
There you go. It's not bad. We're all coping.
Yeah, for sure, absolutely.
I saw you've been there for a dozen years, which that's a long time for one firm, actually. How'd you get into this? I mean, I'm in DC. People get into esoteric areas of the law. How did you sort of wind up doing whistleblower law, which is not necessarily the first thing that I would think people hear about when they, think of law work and that kind of thing? I mean, what led you to it?
Yeah, thanks, Tony. Well, I work at Nichols Kaster in Minneapolis, Minnesota, and we have about 30 some lawyers, and we practice exclusively on the plaintiff side of litigation. And our roots really come from employment law. So, for a few decades there, we practiced almost exclusively in employment law. And qui tam is really a natural extension of employment practice. Obviously, a lot of whistleblowers are employees of the companies that they are blowing the whistle on. And, we have a lot of retaliation cases from whistleblowers who are trying to, kind of make the fraud or the illegal activity known. And so just throughout the years, these cases just kind of fell in our lap, here or there. It's as a natural extension of our normal employment intake. And I would say we took whistleblower or False Claims Act cases just kind of on an ad hoc basis like that for a very long time. It hasn't been until the last couple of years that we've made a concerted attempt to develop more of a whistleblower practice. Mm-hmm. And now we're being more intentional and looking for these cases more specifically and trying to grow our practice group in false claims.
Yeah. Okay, that's interesting. Do you like them? Are they? I mean, you either are into this stuff or you're not. It's sort of hard to do it halfway. I think you get very, there's such complicated big cases that one tends to either like that kind of thing or not. I don't know.
Yeah, no, I do like them. So for most of my practice, I focused primarily on large class or collective actions where I represented a lot of employees who were treated unfairly by their employers. And so that kind of like that complexity of a class action, mm-hmm. and just like it's difficult and there's a lot of strategy and much more motion practice. I kind of find that challenge, if you will, in litigation with False Claims Act cases. They are complicated. Yeah. You basically have to learn a whole new area of law or regulation in order to even get your hands around it to see if there really is a there. But in much of the same way, the thrill I got from the complexity of a class action, I feel like that translates pretty well into qui tam cases.
I was going to ask you about this because every 2-3 years I have this headache. I haven't really figured out how to do a class action and a qui tam at the same time with the same. And I've had a few cases where if I could, I would have. Have you ever figured that one out? That's to me like it theoretically you could, but in reality, I don't know how you get with the seal and figure out how to do that, and at the same time, get around filing under seal a False Claims Act case while you're pursuing the litigation of a class action. Is it just too cumbersome to even really think about, or So I have a guy right now who, God love him, he might have one that could work that way, but
Oh, wow. No, I think that's an interesting question. Usually when we look at it, it's usually a this or that situation. So we hear like something really bad is happening, and then we find out that they've already, disclosed it publicly, and we go, okay, maybe this is actually a consumer class action case after all. Maybe
yeah,
this is a False Claims Act. So sometimes I would say most of the time the facts kind of lead us into one lane or the other, and we don't really get a choice. But
yeah,
if you figure out a way to maintain both, that would be really something. That'd be really interesting. The one thing that would make it hard is, especially if you're in a district where your assistant U.S. attorneys traditionally take a very long time to investigate, that
mhm,
would be a real challenge for a class action, because you need to, once the seal is lifted, you've got to get a case certified, and you need to be able to get your information in discovery. And if a lot of years have passed, maybe the relevant documents are gone, or maybe the relevant witnesses are gone, because it's not going to be quite the same issue that the government was looking into in their investigation. So you run the risk of maybe making the case harder for yourself if you're in an investigation for a few years. And then you have sort of competing loyalties, right? Because you have some loyalties to the government, but then you also have loyalties to your class, and you kind of have to worry about potential conflict. Obviously, it depends on the fact pattern, right?
yeah, yeah, it does. I mean, I just honestly, I've not been able to make it work, and I wouldn't say I've had very many, and I don't consider myself a class action person. I would, partner with a firm to figure that one out, but I just haven't been able to figure out how that's doable. Maybe it is, and I'd love it if it were, because it would mean that it would give us sort of a lane to do, many bigger cases.
Yeah, let me know if you figure that out, or send me your press release once you got one going.
Well, maybe I'll write you about the case. I don't know. It's pretty wild. I've got a pretty wild matter, but obviously it's not something I can disclose. But it's pretty wild. You litigate these cases. Um, uh, most, I wouldn't say most False Claims Act cases, let's put it that way, don't get litigated. I think that's a fair thing to say. In fact, I was looking at the statistics. The DOJ statistics came out, I want to say a couple weeks and months ago, and it was the same as it always is. 80-90% of the cases involve DOJ intervention. Okay, some of those are intervention very late in the game, but still 80-90% of the cases relate to healthcare for any number of reasons. And yet, you're willing to litigate. That's pretty exciting. How many of them have you litigated? Do you want to litigate more? What's your story on that?
So litigating past declination is more of a newer strategy for us. This has been, the last couple of years as we spend more time on these, gathering a practice group for this area. We have done it in the past before too, as well. But yeah, it's harder. I would say the reason why we're doing it, and we'll see. I mean, will we come to regret it? I don't know. But I do think that the strategy is itself an extension of our firm culture, actually. So we tend to take risks in this way. For one thing, litigating past declination is traditionally coming to us from co-counsel. So a lot of attorneys that we know, both plaintiff side employment lawyers and more traditional relators attorneys, coming to us looking to partner on these things. It just provides a great opportunity to get involved in some really exciting cases that we otherwise don't have coming across our plate right now. But we really do, we do this sort of thing. I can kind of analogize it to something else our firm has been doing for about over a decade. Obviously, big corporations started using arbitration agreements, and back when Concepcion came down, to put a quash on class and collective actions. And a lot of cases went away, but illegal activity didn't stop happening. It just became really impossible for employees or consumers to seek redress for that illegal activity. And we've made a concerted effort as a firm to bring mass arbitrations and make companies regret these choices, it's very expensive for companies. And this way we can still try to get relief for workers who are willing to kind of stand up and go through the process. And we co-counsel with plaintiffs' lawyers all across the country to do this. We've also set up a website for plaintiff side only lawyers called arbitratorrater.com, where we are tallying reviews of arbitrators to make sure that plaintiffs' lawyers can go there and look and make sure that they are picking somebody who at least is going to give their client a fair shot. So kind of fighting back against arbitration agreements, it's more work, it takes a lot more resources. It's not exactly a streamline, low-hanging fruit kind of thing, but we think that the act will over time pay off, and we think that companies will over time concede and go to court, or at least that's the goal. And so we're trying to change, not policy, but we're trying to make a change in employer practices. And as you said yourself, Tony, when it comes to litigating past declination, the DOJ can't take most cases. 20% is, a pretty steady number you hear. That there's no way that the other 80% are all bad. There's plenty of cases in that 80% that are on the merits worthy of pursuing. So yeah, it's harder. It's definitely an uphill battle, but you could have a good case. And I think there's value in pursuing those good cases. So it's just a matter of resources, and I think we have them. So we're willing to take on the challenge, and so far so good. But let's talk in your podcast in a few years and see if the strategy changes.
Well, I would say even the DOJ would admit, not even the DOJ would readily admit that they can't. And, maybe this is a discussion we need to have with some folks in the community about getting the DOJ more resources, but they would readily admit that when they decline, they don't by any stretch think they're declining only meritless cases or something like that. And and that's a real problem, because it convincing judges that the government has declined your case doesn't mean anything on the merits is a high hurdle for all of us to go over. I was wondering if you gave any thought towards litigating to a certain point. Is it possible to litigate just through summary judgment and drop it at that point, or is it just too hard? You have to be prepared to go the whole distance if you're going to take it up, or how do you view that? How's your firm thought about that?
I think if it's going to be worth the risk, it should be a case that you're willing to take all the way. And, things change in discovery, and maybe that means the case value plummets and a reasonable settlement is a lot smaller, but I think you got to be willing to see it through. If for some reason the facts really don't bear out and you need to walk away, that's probably going to be an interesting negotiation with the other side, because you want to make sure that they don't try to go after you for any sort of costs or fees. If you litigate it too far, it gets hard to voluntarily dismiss under the rules. Yeah, no, that's true. But even when the DOJ is making a merits-based decision, they just have a higher threshold than your run-of-the-mill plaintiff's employment lawyer, for example, because they're not looking at, do we have enough to get over a motion to dismiss and get into discovery and get the information we need? They usually want you to satisfy all the elements, wrap it in a nice tidy bow before ever needing any discovery, right? So they're holding a case that they're evaluating to a much higher standard. I'm speaking generally there, but
No, I think you're right. I think they'd admit that. I think, look, they don't. They're very worried about writing bad law, and that's a reasonable concern. And they're not interested in taking, the type of risks that private counsel has a reason to take, I guess you'd say. The other thing I think we don't appreciate, and maybe nobody really appreciates this, but I had a case I was involved in a long time ago. It might have been the first complaint I ever worked on in my old firm. And the government ended up doing the case. And it took 17 years of a DOJ attorney's life. And a great case. But like, if you're a government employee, maybe you don't want to invest your entire career on a particular case. And some of these cases are big enough that they not only could last a long time, but also can take over your whole life. And we tend to forget that. They're human beings. They don't necessarily want to do that. I don't know.
That's a good point.
Yeah,
maybe if more of us take these cases past declinations, courts will stop looking at these cases as presumptively bad just because the government didn't intervene, right?
Yeah, I think that would help. I really do.
Normalize it a a little bit.
Yeah, I think that would really help, because we're all, the first thing we see out of defense counsel, is it's not an all-purpose fraud statute, and they turned it down and go away, and and it's declined, and all that kind of stuff.
My favorite response to that right now is, Escobar was a decline case, because every motion to dismiss involves Escobar these days. So just kind of reminding the court, Escobar was a decline case. So it obviously was worth, pursuing. We're all talking about it still. And that's just kind of one way to deal with that. But yeah, I hope we can normalize pursuit post declination, especially, if the government decides not to move to dismiss your case. That should be looked at as favorable. Yeah. Shouldn't it go both ways?
It should go both ways. They make a big deal out of that the government could dismiss it. Well, what if they don't? There was a case in Florida, actually. The Florida statute is really bad, or really permissive, I should say, for dismissal. A case that actually made it through a motion to dismiss, and then the AG dismissed it. How'd you like them apples? you go litigate it. Yeah. But I don't think you could really do that under the federal DOJ standards. But anyway, we'll see how that goes. Is there a particular area you're looking for? Are you looking for healthcare? Are you looking for defense contracting? Is it just whoever shows up with some nice piece of work that you're interested in? What are you looking at these days that looks good? I realize healthcare is 80% of it, but there's nursing homes, and there's pharmaceuticals and medical devices, and all. It's kind of a world unto itself.
Absolutely.
Is there any particular area that you think you'd like to see more cases in, or think maybe more to the point, do you think it's underreported?
Mm-hmm.
I don't know how you feel about that.
That's a good question. The vast majority of what comes across my desk is healthcare related, but you're right. There's a lot of different things that make up the healthcare bucket, right? So that's the majority of what we're looking for, or looking at, no matter whether we want to or not. That's just the bulk of the work. I'm actually really excited to see, as investigations complete and cases get unsealed over the next year or two, I'm excited to see what's been happening with all of these PPP loans or other pieces of the COVID relief that have been happening over the year. I think that's going to be really interesting to watch play out. But I don't know. You have a lot of pieces of our government are being privatized these days. So you just have a lot of companies who are stepping in and acting as quasi-government arms. And so there's a lot of opportunity there for abuse and misuse, especially when these companies are motivated by profit. So I think we have to be diligent and kind of look in all spaces and pursue, whatever obvious fraud we find. But I don't know if I have my finger on the pulse any more than you do, Tony, as far as what else is coming up the pipe.
Well, I don't either. I must say, though, that like in the past 4 years, they sort of shut down litigation over HUD stuff. I'm really hopeful that the new administration will say, wait a minute, that's a viable kind of case again. So I am hopeful about that, as well as for-profit education, which I think got it didn't get completely wiped out under the previous, but it could come back. The PPP stuff or the COVID stuff, I tend to think you'll see stuff 2 or 3 years from now coming out of SEAL on the higher end.
Yeah.
I don't think the little $1 million loan here and there. I mean, you and I are not going to file a case over $1 million, some franchisee of Subway's $500,000. But some of these loans for some of these operators that weren't under the PPP program, but were under the other stuff, that was real money. And it's going to be interesting to see what happens with that. It's also going to be interesting to see if they roll back some of the Stark law changes that they made to try and make it more possible to do telehealth. That's going to be a wild new frontier. Prescriptions under telehealth, and because everybody's going to get prescriptions under telehealth, and some of them will be perfectly legit, and some of them will be mills to make money for folks. So
right.
That's my take, but who knows? We'll see what happens.
What do you think? Like thinking even bigger, like what do you think is going to be possible with the change in administration? Like, are we going to be able to do key TAM claims for taxes one day? Are we going to
Yeah, I do. I actually do. There's actually the DC added a key TAM right, or a right under its False Claims Act case to go after DC taxes, following the New York state model. And I think there's another state out there that's doing that. So yes, I also think it's like one of these things. We need like a really big hit under the California insurance or the Illinois insurance key TAM, and then all the states will want to do it, right? Because then it'll be money to them. So I think you'll see some of that. I think the new anti-money laundering whistleblower law is a start, but it hasn't gotten. It's like. There's some things about it that need to be fixed for it to be a good law, but I think if they do, it'll be a good law. And I think the NHTSA, this is a whistleblower law for motor vehicle safety. It was enacted 5 years ago. They don't have any regulations for it yet. I think this administration might write those regulations, and we'd have a whole new law and a whole new ball game. So yeah, I do think I think it's an expanding area, and I think particularly given that, who's kidding who after the COVID hits, the government's going to need money. They're going to like wake up and go, oh yeah, maybe this is a way to get some money,
Right.
At least I hope.
That's the goal.
At least I hope. I really can't tell you how much I admire that you're willing to pursue these cases out of SEAL. I think that's courageous. I wish I had more trial experience doing it, but when you do this stuff full time, you don't get very much trial experience doing it. So I try to add value to people I work with, sort of in the back door of it. But I really admire that you're willing to do that, and I hope whistleblowers admire it. I mean, it's not easy to be a whistleblower, and it's not easy to bring these cases, and it's always an uphill fight. And so I appreciate that you do that, and it's fun working with you. So I hope we get to do it some more.
Absolutely, thank you, Tony.
Thanks for your time.
No problem. Excited to see what the future holds.
Yeah, thanks. See you soon.
Talk to you later.
Bye.
Thanks for tuning in to this episode of the False Claims Act Insider. Be sure to check back next week for more insights into the world of whistleblower and key TAM law with your host, Tony Munter. All episodes can be streamed on pricebenowitz.com along with your favorite streaming platforms.